Here I've tried to prepare a chart which compares an estate plan that revolves around a revocable living trust versus an estate plan that does not have a revocable living trust. I've divided the features into lifetime needs and needs for the disposition of property after your death. So if we look at the chart, you'll see under the heading lifetime needs, first is financial management for yourself. The idea is if you become incapable, how is the management of your property going to be dealt with? And of course, because revocable living trust is an agreement and does have provisions in it dealing with lifetime issues, it certainly can provide for financial management of your property if you become incapable. If you don't have a living trust, the alternative is a power of attorney. Now, a power of attorney is a relatively simple form. When you sign a power of attorney, you are appointing somebody to be your attorney in fact. Call that person your agent. So you're appointing an agent and giving that person a lot of authority to deal with your assets. And that person's a fiduciary, which means he owes you a duty to use that power not for himself, not for the agent's benefit, but for your benefit. The thing about the power of attorney is if you name your best friend as your agent under the power of attorney and your agent dies or becomes incapable, the power of attorney is ineffective. With a living trust, however, you could name your best friend as trustee of your living trust, and the trustee might die. Your best friend might die or become incapable himself and not be able to serve as trustee. But that doesn't mean the trust document becomes ineffective. It doesn't mean that the trust is no longer useful. All it means is another trustee must be appointed. And usually the agreement will include provisions for successor trustees. If one trustee cannot serve for some reason, another trustee will be identified. Or there's a procedure in there for the beneficiaries to identify a new trustee or for the probate court to identify a new trustee. So because of that, revocable living trusts are typically thought of as a superior way to deal with the management of your assets during your lifetime because it's a more permanent solution, whereas powers of attorney, they are not permanent.
Also, with a power of attorney, you can't be 100% certain that the agent will be able to make a transaction happen. The reality is that bankers and brokers have seen too many transactions where powers of attorney have been abused, and they become more and more reluctant to honor them. So if your agent attempts to withdraw money from your bank account under the authority of the power of attorney, the banker may be reluctant and resist, especially if the power of attorney is old or looks different, or if you and the agent are complete strangers to the banker. Legislation has been enacted to try to impose a duty on third parties, like bankers and brokers, to honor a power of attorney. For example, effective on October 1st, 2016, Connecticut has such legislation, but it isn't perfect, and you still can't be 100% certain that the agent you appoint under the power of attorney is actually going to be able to make a transaction happen quickly and without a hassle.
That's not true with a revocable living trust. When you have a revocable living trust and assets are in the trust and the trustee is managing those assets, as far as everybody else in the world is concerned, the trustee owns that property. It's not a delegated power. It owns that property as the owner and can deal with other people without those other people feeling uncomfortable about it. When it comes to management of the assets while you're alive, keep in mind the revocable living trust is an agreement, and it can provide for all sorts of things while you're alive. And one of the things it can provide for is that if you become incapable, your assets can be used for the support of others. So there can be extensive provisions in the revocable living trust to deal with that possibility. If you don't have a revocable living trust, the question is, well, if you become incapable, is it going to be possible for your assets to be used for other people? And typically the answer is no. I mean, you can provide for giving the agent under your power of attorney the authority to make transfers of your assets to other people. In other words, the authority to make gifts, but you can't do it in as circumscribed way as you could in the living trust. And then the agent under your power of attorney might be a little bit worried. He's supposed to exercise this power for your benefit, not for the benefit of others. He's supposed to exercise that power as a fiduciary. And so maybe he'd feel comfortable doing it if it was to satisfy a legal obligation of support or something of that sort. But without actual language written into the power of attorney, the agent under the power of attorney would not feel authorized to use your assets for the benefit of others. Let's talk a little bit about what happens after death when a revocable living trust is kind of your primary dispositive document. It's the center of your estate plan versus what happens if you don't have a revocable living trust. Well, first of all, we talked before about if you don't have a revocable living trust, it's necessary to go down to the probate court and ask the court to admit your will to probate. So there's an application process there. There's a paperwork process. And I must say, in routine situations, there's nothing particularly troublesome about the probate application process. In routine situations, it goes perfectly well without any problems. If you have a revocable living trust, and if you've done a good job of transferring all your assets to the revocable living trust so that at your death there are no probate assets, then there's no reason to probate the will. And so that would mean also that there's no reason to have an executor appointed. If you have a revocable living trust, keep in mind you've already transferred all the assets to the trust. The trustee already has possession of all the assets. There's no need for the trustee to go to the court to get a blessing from the court that says that he has authority to take possession of the trust assets because he already has possession of the trust assets. This comparison is continued in the next segment.